live. So
Okay.
sorry, it took a little bit because I was logged in as somebody else. I apologize. All right, you're good.
Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. Welcome, counsel, and also all of those viewing through our Supreme Court Live channel. I want to start the morning by acknowledging that today is a historical day in our court. Justice K.J. Wall will hear his first arguments as a justice today. Justice Wall, welcome. We welcome him and are excited to begin this new period in our court's history. As you know, we also have an impending retirement at the end of this week of Justice Carol Beyer, and she is not sitting with us this week because of that. We'll comment more on that as the week progresses, but at this point, I just wanted to note that we are very fortunate to have Senior Judge Mike Ward, a retired district court judge, with us today. And in fact, will be sitting with us all week on all the cases. For those of you who have not met Judge Ward yet, he has sat with us since last March as a senior judge. He was formerly a district judge in the 13th Judicial District, which is comprised of Butler, Greenwood, and Elk counties. Judge Ward not only served there for that period of time, through much of that time, he served on the pattern instruction committees and in fact chaired them for many years. And so he's given long service to the judicial system and excellent services. So with that, I welcome counsel and noting that we have read the briefs and are looking forward to your arguments. Mr. Shima, the clerk of the appellate court, I will ask him to now call our 9 o'clock case.
Thank you, Your Honor. The docket for 9 a.m. Monday, September 14th consists of one case. Case number 120824, State of Kansas versus Gianni Maissimo DAINO. The appellant has reserved 3 minutes rebuttal.
Thank you, Mr. Shima. Would counsel please state their appearances and note the party you represent?
May it please the court, Sanan Ghazal on behalf of the petitioner, the appellant.
Madam Chief Justice, and may it please the court, I'm Jacob Gonteski. I represent the plaintiff in this case, the state of Kansas. I would note for the court that my party is the appellant in this case, as this was a state's appeal, although this has not been before this court on the state's petition for review. So I represent the plaintiff, the appellant, the state of Kansas. I'm present and ready for argument.
This is one of those cases that tries to confuse us as to who gets to go first and also have the rebuttal. So, counsel, you may proceed with your first argument, Mr. Ghazal.
This case seems kind of straightforward. It seems kind of simple when you first look at it. When a law enforcement officer knocks on the door, the person opens the door, steps back in, and the officer asks, can I enter? He steps back in, and then based on the Court of Appeals opinion, that's kind of where this legal issue ends. Officer knocked on the door, Mr. DAINO opened the door and stepped back. What we are asking the court to consider is the entire context behind the officer knocking on the door. Why the officer was there to begin with. He was there to investigate the smell of marijuana. He was there to investigate a crime. The officer, in his testimony at the motion to suppress, stated that when he did knock on the door, he wasn't immediately right in front of the people. He was off to the side. Wasn't sure if Mr. DAINO could see him or not. Officer never announces his name, never announces that they are there as law enforcement. This was supposedly a simple knock and talk. Knocks on the door, there's a brief conversation. And really the question that the officer asked in this scenario is, can we come in and take care of this issue? He doesn't say, can we enter your apartment to search? He does not say, can we enter your apartment to do anything other than have a conversation, possibly write a ticket. As the dissenting judge noted in his opinion, that essentially there was no way for Mr. DAINO to actually consent without being provided, one, an opportunity to know whether he can refuse the officer's entry or not. Two, what exactly is he consenting to? Is he consenting just into the officer's entry, or is he consenting to the officer's entry into his apartment and subsequent search? The district court only addressed the issue of the officer's entry into the apartment. They didn't really address any of the other points brought up in the motion to suppress, so I'm not going to get too, I'm not going to get into that. But essentially, it all morphs from the officer knocking on the door, walking in, and then subsequently entering Mr. DAINO's apartment, searching the apartment. And I think one of the things that the Court of Appeals incorrectly stated was that Mr. DAINO and all his interactions with law enforcement from the second the door was open, his actions, his behavior actually manifests a very voluntary or willing attitude. I would argue, as did the dissenting judge, that no, I think this was a situation where it was an 18-year-old kid, doesn't know who's knocking on the door. He opens the door. Cops mentioned something about writing him a ticket, addressing the issue, doesn't tell him, I'm coming into your apartment to search. You can tell me no, I can get a warrant.
In your mind, what communication by the officer is necessary to manifest a clear intent to enter the apartment? Does it have to be that, hey, can I come in? I'd like to search. Would that be, that's different than what happened here. What is it that it would take in your mind so the communication between the officer and your client was clear as to what the intent was?
Judge, I would say that, especially when it comes to the search of a home or apartment, if the officer's question is, can I come in just to talk to you? That's one thing. But for what happened in this instance, the specific word that I would say that the officer should have communicated to Mr. DAINO is, can I come into your apartment to search for marijuana? There was never a question about exactly what is he consenting to by opening the door and stepping back. Is it to investigate? Is it to have a conversation? Is it to have a ticket written? None of that is made clear to him.
Counsel, my understanding of the facts, which may be wrong, is that there in fact was a signed written consent for the search, and our inquiry is limited to whether or not there was consent to enter the apartment. My understanding is that was the basis of the suppression motion below. Is that correct?
Yes, Judge. And at the same time, no, that sounds like a very legalese answer, but really the issue was the way the motion was written, the way the issue was brought up was, can there be consent that's non-voluntary? I mean, non-verbal, whether it is to enter the apartment or to search his room. And the way that this was couched was the entry into the apartment was the same consent question as the entry into his bedroom to search for the marijuana. The issue, I believe, that the district court was deciding was whether or not if Mr. DAINO's nonverbal actions, whether it's to the apartment, to his bedroom, can equal consent. And I think the dissenting judge, what he was highlighting is that when you're talking about consent, whether it's into the apartment or to his room or any other location within the apartment, coupled within that is there the consent to search that's tied with it. It wasn't, hey, can I just walk into your room? Hey, can I just walk into your apartment? There was, because it's law enforcement, there's always the consent to search that was, I think,
Do you draw
implicated.
the line? Do you draw the line at verbal versus nonverbal? Can there be nonverbal consent to enter? I think that the trial court judge said no. The cases are clear that it must be verbal. Where are you at in that continuum?
I believe that, well, I guess the argument I would make to this court is in Kansas, when we're talking about consent to enter a home or an apartment, something where the Fourth Amendment itself, as well as Section 15, provides the highest level of protection, that when it's law enforcement, I don't believe nonverbal actions alone is enough. I think
So,
that needs to be made.
so kind of saying waving like this is not enough. It had to be waving coupled with, well, come on in, or something like that. I just want to get your position here. It has to be something verbally communicated.
Yes, I would make that argument.
Okay.
Don't we have to segment what we examine here, separating the entry into the apartment from what was a signed written consent to search the bedroom?
You're saying what was the difference? You said what's the,
Well, no, I'm just saying when you talk about nonverbal consent, are we focused on the entry into the apartment? And is that what the district court focused on? Which then raises the question, is that all we have before us? Because is that the extent of the district court findings, is just the entry into the apartment?
yes. And whether or not verbal or nonverbal actions on behalf of Mr. DAINO could constitute valid consent.
So would your view be that any consent about the search of the bedroom is not yet teed up for our consideration?
Yes,
That would-
yes,
that
I
would
would
be-
agree with that. Yes,
Potentially the next issue in the district court, if we were to revert, if we were to say that there was sufficient consent to enter the apartment, we haven't, and nor has the district court reached the question about whether there was a voluntary consent for search.
right.
Okay.
And didn't the district court limit its findings in the same regard? He got to entering the apartment. That's it. I think that may be a direct quote from the transcript itself.
Yes,
So the sole question in front of us is, if I open the door and kind of wave someone in, is that sufficient to allow the law enforcement officer to enter the apartment?
I would say as far as the issues that were decided, as well as by the appellate court, that seems to be the singular issue, is whether or not you can have consent through nonverbal actions. And I think what I was trying to get at is, as well as the dissenting judge, is that when it comes to the issue of just the entry into the apartment, the consent that was really being asked by the officer is consent to into the apartment for the purposes of searching. Yes, there was a subsequent consent form that was signed, but I think, as I stated earlier, I don't believe that Mr. DAINO could really voluntarily, unequivocally consent without knowing, one, that he had the ability to say, no, you can't come in. Two,
Yeah, kind of getting back to my first question is what, in order to allow the entry, either verbally or non-verbally, does it have to be communicated by the officer what they're coming in for?
that would be my argument. I think that when the Supreme Court in Florida, I think Hardinez, said that knock and talks were constitutional. The idea was that they're just like any other person that could be walking up to your driveway. I think the example that they used were Girl Scouts selling cookies. I would make the distinction that when it's law enforcement, either under the Kansas Constitution or even the Fourth Amendment, because the knock and talk has not really been addressed since then, that it has to be clear who is knocking on the door and what the purpose for the entry into the apartment is. A Girl Scout cannot get you a ticket, or just in this particular instance, a felony, as Mr. DAINO is charged with. I think that's all I have.
Counsel, one of the things at the heart of this is a legal question, whether or not nonverbal actions can ever be sufficient to give consent. It seems to me there's arguably at least some factual components as well. My question is, do you think that the Court of Appeals engaged in fact-finding?
Yes, I do believe that one of the issues I had was that I wasn't able to dispute the officer's statements when it came to the Court of Appeals. And I think that the fact finding that the Court of Appeals made was specifically what did Mr. DAINO do, as well as his behavior after the officers entering into the apartment, if that constituted.
And quick follow-up, was there any fact finding in that regard at the district court level? Because that's something I couldn't tell for sure.
Which is also raises the dissenting judge had stated that there was different, as far as what actually happened, I think it is disputed. I think that it is not quite as controversial as the state would make it. And that I think the only facts that the district court really made a decision on was, regardless of what happens, nonverbal actions can never equal consent. Which that
was the lower court. Sorry.
Didn't the district court decide that there was clear and unequivocal consent non-verbally?
I believe his decision was that he would find it consent if it wasn't versus State v. Polton, and that the district court's, I think, understanding of the law is that there could never be any kind of consent that's nonverbal.
And wouldn't that be a fact finding then by the district court that would support the Court of Appeals? In other words, that goes directly to my first question, which was the Court of Appeals actually engaging in fact finding, or was the Court of Appeals simply taking the district court's fact finding?
Just in response to your question, I would say that the Court of Appeals, and my understanding of their decision, their rationale, they did not go above any, well, actually, I was answer your question. I would say that I don't believe they made additional factual findings aside from what the Judge Sutherland has said was, in his opinion, any reasonable person would have found this as consent.
And I take it from what you're saying that you accept that the court or the district court made a finding of fact that it was only nonverbal. And the reason I ask that is because there is evidence in the record, confusing testimony, I think, by the officer, at least when you look at it, that says the officer said that your client said, okay, let's do this. And then later the officer said he didn't recall there being any verbal response. So do you take the district court findings to be a credibility determination, or maybe not quite the right word, but just a weighing of the evidence to be that there was a nonverbal response? rather than an ambiguous, perhaps verbal response.
No, I would say that there was not a verbal response. I think as far as the district court's finding, as the officer's testimony was kind of muddying the waters there. At one point he said, he did say something. Later on he says, oh, actually, I didn't hear anything. His earlier testimony was that he stepped back and hung his head and stepped back. Later on, at the motion to suppress, his testimony was that he made this sweeping gesture that was not testified to at the preliminary hearing.
Are there other questions for counsel? Thank you, counsel.
Thank you.
Mr. Gonteski?
Thank you, Madam Chief Justice. I'm Jacob Gonteski. I represent the appellant, the state of Kansas in this case. Mr. DAINO absolutely gave unequivocal, specific consent for officers to enter his apartment that day. And that consent was freely and voluntarily given. It's that consent to enter the apartment that is the sole issue in this case. The search of the bedroom later and other evidence recovered within the apartment is not the issue here before this court. The defendant did file a motion to suppress on multiple grounds, on multiple fronts. And the district court, in first deciding the issue to enter, once the district court suppressed the evidence on the basis that the entry was not with consent, the district court then declined to reach all of the other issues, finding them they didn't need to be reached because the suppression at the doorway was all that was needed. So that's the issue that's narrowly before this
Counsel,
court.
let me just
Yes.
jump right away and focus on the issue that I talked to your opposing counsel about. In your view, did the district court make sufficient fact findings with that you just recited, that the nonverbal consent was unequivocal, specific, freely, and intelligently given? Was that fact finding actually made prior to the legal determination that ended up costing the state the motion, essentially?
I believe those fact findings were made on multiple occasions. The district court recounted specifically, and this is where credibility determinations are made at the district court. And this is precisely why, because the district court recounted how the officer demonstrated when he approached the doorway and when Mr. DAINO opened the door and they interacted. The officer gestured, he demonstrated how the interaction went. And the district court judge actually recounted that demonstration by the officer, and he put it into the record by stating that the officer talked about how Mr. DAINO, after the officer asked if he could enter to get the things resolved, Mr. DAINO opened the door more widely, hung his head, and he gestured by making this sweeping gesture with his right arm across his body. And that's where the district court made the fact findings that are relevant to this narrow determination. The district court further went on to summarize it by stating, quote, to state that the way he interpreted this officer's testimony, and when the officer testified that he understood DAINO was consenting, and then the district court stated anyone in America with any sense would have construed this as come in my apartment.
I agree with that, but that's my question. Is that enough? Because that's not exactly what we would normally expect to see with regard to a fact finding of a voluntary consent freely given. It's more the court's sort of recitation of the facts, but the district court judge knows that at the end of the day, the ruling's going to be that as a matter of law, that's not sufficient.
Right.
I guess. Help me with that.
He did make the ultimate legal conclusion that that was insufficient because the district court, and that was the one error the state asserts the district court made, was the error in misreading Polton to basically say that Section 15 of the Kansas Constitution requires explicit express consent, and express consent can only be given verbally. In making the determination that that was legally insufficient for consent. But I believe before that, the district court's recounting of the officer's testimony was a sufficient factual finding because he talked about precisely what the officer encountered. They went through the nuances of the words that the officer used and the lack of words from Mr. DAINO. And the district court went through how the officer's demonstration of that interaction played out. And I believe those are the fact findings.
If we agree with you on the legal question, if we were to ultimately agree with you on that, why wouldn't we? I mean, it seems to me the normal course would be to send this back to the district court to have a proper understanding of the law, and then to apply the district court's role as fact finder to the proper legal standard. Why wouldn't we do that here? It seems to me the Court of Appeals arguably just skipped that step.
I believe you could do that here if you felt as though the district court's fact findings were insufficient to support that legal conclusion, but the legal conclusion itself was simply an error of law. That's one of the state's contentions, but it was this district court's fact findings were sufficient in how they interpreted the officer's testimony and his credibility. I'll note also that the district court was asked specifically if they found the officer to be credible, and he said absolutely. And so, and there was no countering evidence. There was nothing disputing the officer's testimony. There was no other evidence that countered it. And so I see your question as being one where believing the Court of Appeals sort of leapfrog past the fact findings issue, but I believe as though they didn't exactly leapfrog past it when they recounted what the district court saw from that officer. So in the event this court finds those fact findings to be muddied or wishes they did have more clarity, another approach that could be taken is the one that you just recounted, which is to clarify the state of the law, which is that number one, consent to enter can be implicit. It doesn't have to be express. But furthermore, whether it's express or implied, consent to enter can be given non-verbally. It's simply an error of law to find that consent to enter a home or an apartment must be given verbally. That cannot be the state of the law. It is not the state of the law. Not every person is physically capable of giving verbal consent. To say that those individuals could never consent to an entry to their home simply because they can't provide a verbal response simply can't fully state the spectrum of scenarios that officers find themselves in at various times. So whether you find Mr. DAINO's actions through his gestures as being express consent or implied consent, either were sufficient and sufficiently clear to these two officers at that doorway and clear to the district court judge who weighed the credibility of those officers' testimony to be unequivocal and positive consent for those officers to enter. The question of consent to search and consent to go into the bedroom and recover other evidence and seize evidence, that is a separate issue. It's an issue the district court did not yet decide. It's a separate issue that Mr. Gaza did raise that is still pending before the district court should this court send the case back to the district court. So, and that is one point that I wanted to make in response to Judge Boozer's dissent with the Court of Appeals. One of the issues he took was in stating that the consent was not voluntarily and intelligently given here was, he argued, because the consent did not pertain to exactly why the officers wanted to enter and what the officers ultimately did while they were in the apartment. But that's not part of the consent analysis. The consent analysis doesn't require the officers to predict and foresee exactly what they're going to encounter and what actions they'll take once they're inside. The consent to enter is just that, the consent to physically enter into the space and nothing more.
Can it be based on anything, the consent to enter? I mean, could the officer have said, hey, I need to make a phone call. Can I come in and make a phone call? And he waves them in. Doesn't there have to be some nexus as to why the officer is there in the first place and the entry? And that's what I think Judge Boozer points out isn't clear as to why the entry is necessary in the first place. And there has to be something. It can't just be for any reason. Oh, come on in.
To the extent that, well, I don't believe it can be for necessarily anything. But that does raise a separate issue as to whether or not if the officers gave one reason that they wanted to enter and then they encounter other facts and other issues confront them once they're in, are they then hamstrung by the consent as to the reason given. So, but setting that aside, to the extent that this court would like to see or would require a nexus between the reason for entering and the consent that's given, that was present here. It was abundantly clear to everyone at that doorway. When the officers came to that doorway, the first things out of their mouth was, "Oh yes, it's here," because they were there looking for, they smelled an odor of marijuana outside of an apartment complex where the doorways for each unit face the outdoors. There's no interior hallway. So they scouted around, they spoke to an individual on the scene. They end up on this stairway, up in front of this exterior doorway of Mr. Daino's apartment. And they knock for a while. And when Mr. Daino ultimately opens the door, that's when they're confronted with this odor of marijuana emanating from the apartment, both burning and raw. And they say, "Oh, wow, it is here." And they tell him right off the bat that they smell the odor of marijuana, they smell weed, and that's what they're there to resolve. So it's not as though they were hiding the ball on why they were there or why they wanted to enter. They didn't do it under some guise or some misleading statement that they wanted to do something less than resolve the issue of the marijuana and the smell that was coming from the apartment. So to the extent,
so in your mind, that would be sufficient. They're here, they smell the marijuana, they're talking about it. Can I come in? That would be enough.
Correct. That would be enough. For this purpose, that would be enough simply for the entry, for the consent to enter. That I'm not talking about the consent to search and so on.
Right.
If that isn't sufficient, I'm hard pressed to imagine what would be. Rather, beyond to take it to require more would be to require the officers to start recounting long volumes of exactly the state of the law on marijuana and what they might do and all the different scenarios that might confront them upon their entrance to the apartment. So they're not in a position to be standing at a doorway and recount all the possible scenarios they may encounter once they enter. But what they're there to do is give him the broad brush view as to why they're there at the door and why they want to talk to him. And that's what
I'm sorry, counsel. Factually help me step through the sequence of when they say something about we just want to write a ticket. And how that impacts what you have just argued. Does that play into whether there was a misleading of information to?
At the outset, when they first come to the door, there's the testimony came from both the preliminary hearing and at the motion to suppress. To the extent that there are disparities between the two, it is in part because the preliminary hearing does not examine the nuances of all the possible areas where a motion to suppress might lie. A preliminary hearing is just that. It's a preliminary hearing just to set forth the basic facts. So the officer's testimony about the entry at the preliminary hearing was fairly limited. It's a bare bones amount of information. But at the hearing on the motion to suppress, he got much more specific. When Daino opened the door, then the officer was standing there, and McKieran, the officer, testified at the hearing on the motion to suppress that he did not recall hearing Daino respond verbally. The Court of Appeals did note that on the audio, there is a portion where it sounds as though there's a verbal statement made in that gap. The officer did not testify that came from Daino because that wasn't what he recalled. He didn't recall who the statement came from, so he wasn't going to put it in Daino's mouth. But what the officer's statements were and what was supported by the audio was, he states at the door, "How's it going? Oh, wow. Yeah, it's here. Okay, you've got a bunch of weed in here, man." And he could smell that odor. He said, "Well, here's the deal. Not a huge deal, but I've got to write a ticket if there's marijuana in the house, okay? Because it's illegal. So let me step in with you real quick and we'll get it figured out, okay?" That's his statement. And that's from volume 7, State's Exhibit number 8 from the audio. So I don't believe there's anything misleading there. The officer could write a ticket for a small amount of marijuana. That is within his purview, and that is what was in his mind at the time that he might be required to do. He went in there and began speaking with Mr. Daino, and more information came to light to both Officer McKiernan and his partner that there was a lot more going on in that apartment. And their investigation took a route that ultimately resulted in Mr. Daino's arrest. And that was, yes.
Don't those factual nuances just emphasize that it's our job to clarify what the law is on the question of verbal consent, and it's the district court's judge to evaluate those factual nuances under the clarified law if we were inclined to agree with your legal principle?
In this case, absolutely, because that is what the issue is before this court. The fact findings are not in dispute. They're not at issue in this appeal. What is at issue in this appeal is the legal conclusion. And so the district court is in the best position to do that. And the district court, the single error the district court made, and the one that I've stressed all along the way, was interpreting exclusively Section 15 of the Kansas Constitution Bill of Rights, because you'll note that the legal conclusion drawn by the district court did not rest upon the Fourth Amendment. In fact, he said, I believe in federal court under the Fourth Amendment, this consent was valid. But I find under Section 15 of the Kansas Constitution, this consent was insufficient because it was not verbal, and consent under Polton cannot be given impliedly or implicitly. In recognizing I'm out of time, I'm happy to respond to any questions the court may have, but it is a very narrow legal question here. And the request I'm making of this court is to affirm the Court of Appeals decision, which reversed the district court's erroneous legal conclusion that the actions of Mr. DAINO that day did not constitute consent.
So you're saying that the nub really is the clarity and intent of the communication, not the manner of the communication.
The content of the communication absolutely is what's relevant. And it may take many different manners. It may take the manner of a verbal statement. It may take the manner of a note that's written on a piece of paper. It may take the form of gestures. It may take the form of all the various ways that the nine of us are here communicating today. It's not just one way, it's multiple different ways. And so the manner of the communication absolutely is not what's relevant, Justice Wilson. What's relevant here is the content of that communication. And the content of the communication here was abundantly clear to everyone standing at that doorway that Mr. DAINO was allowing the officers to enter. This was not mere acquiescence. This was not DAINO just turning away from the doorway and walking deeper into his apartment and the officers then follow. That's a problematic approach, as explained in other cases that both parties have briefed. Mere acquiescence is not what happened here. Much more was in Mr. DAINO's communication to the officer. When he hung his head, he opened the door more widely, he gestured broadly into the apartment and yielded the right of way to allow that officer to enter.
Quick question on the interplay between Section 15 and the Fourth Amendment.
Yes.
Are you asking us to rule that that Section 15 mirrors the Fourth Amendment and then look to Fourth Amendment law, or are you asking us to perform an independent analysis of Section 15 on the presumption that it may mean something different than the Fourth Amendment?
I am not asking for an independent examination of Section 15. Section 15 has been interpreted by this court to mirror the Fourth Amendment for decades, going back more than 50 years. And as recently...
So you're just asking us to stick with our precedent that says that Section 15 protects exactly the same interests as the Fourth Amendment, and then we can look to federal Fourth Amendment law.
That's precisely what the state is requesting here. As recently as last month, this court reaffirmed as much. That was in the state's 609 letter. I'm not asking this court to diverge. I have no reason to ask this court to diverge. Nobody in this case has asked this court to find the two provide different protections. There's no justification for as much.
Thank you.
Any other questions of Mr. Gonteski? Thank you, counsel. Mr. Gizai, you reserved time for rebuttal.
Yes, thank you. I think as far as what I'm asking this court to really determine is whether or not, one, if we're going to be using State v. Polton as the precedent, in this specific factual scenario, whether what Mr. DAINO did constitutes consent, whether express or implied. I am asking this court, at least based upon the district court's finding that Section 15 under the Kansas Constitution is what gave him the legal conclusion to make the determination that a nonverbal conduct cannot equal consent. I think what is really at the heart of this issue or this question, at least as far as Kansas Constitution is, should Kansas citizens have more of a protection when it comes to their home or their apartment? Should there be something more that is needed when officers are the ones knocking on the door, not Girl Scout cookies? And I would say that that's what the court should make a ruling on, is in the ways factually progressed from the fact that Mr. DAINO had no opportunity to see it was an officer before opening the door. Officer never announced himself. Coupled with the question is, let me enter and we'll get it figured out. It was mere acquiescence. Officer's original testimony was that he leaned his head down and stepped back. The sweeping gesture, that was the district court's resuscitation of what the officer's testimony was. I would ask this court to rule that when it comes to an apartment or a home, Kansas citizens should have more of a protection when it comes to law enforcement, as far as what is expected of law enforcement when they're asking permission to enter into an apartment. I'll yield the rest of my time.
Thank you to both counsel for your argument. The court will take this appeal under advisement. We are now in recess until 11 a.m. Thank you.
Thank you.